Appearing on behalf of His Excellency and arguing that the President was improperly named as a respondent to the matter, Attorney General Anil Nandlal cited that in the past, several cases have been brought before sitting presidents but have failed. He reminded the court of a matter brought by political activist UC Guyana against then-President Hugh Desmond Hoyt, accusing him of usurping the power and functions of the Election Commission. He further reminded that the presiding judge in that matter dismissed the case, citing Articles 180 and 182(1), which speak to the procedure by which the president can be removed from office, as well as the immunity of the president. Nandlal further highlighted case logs from another Commonwealth country, Sri Lanka, which he pointed out has commonalities with Guyana's constitution, and especially as it relates to civil and criminal matters being brought against the president. According to Nandlal, a magistrate from that country was forced to dismiss a matter brought against the president based on the laws of immunity. On that note, Nandlal asked that Justice Persaud find the case brought against President Irfan Ali to be frivolous and vexatious, and therefore asked that it be dismissed. Attorney-at-law Selwyn Peters sought to discredit the AG's arguments, specifically as it relates to the case logs he mentioned, citing that they were badly adjudicated, while he attempted to swoon Justice Persaud to the merits of his arguments. Peters sought to establish that there is a separation between the president in his personal capacity and that of his official capacity. In that regard, he argued that the president has been properly named in his personal and not official capacity as a respondent to the matter. He also reminded Justice Persaud that in democracies there is no absolutism. Article 182(1) of the Constitution states that subject to the provisions of Article 180 of the Constitution, the holder of the office of the President shall not be personally answerable to any court for the performance of the functions of his or her office, or for any act done in the performance of those functions, and no proceedings, whether civil or criminal, shall be instituted against him or her in his or her personal capacity, either during the tenure of his or her term in office or thereafter. The Police Service Commission approached the court asking it to find that the president erred in judgment when he suspended all the members of the Police Service Commission back in June. Justice Persaud, after hearing the arguments of both sides, set September 16th as the date where he will deliver his ruling on the matter. Reporting for the HGP Nightly News, Wendell Badree.